Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're here for Comment Counsel. So this is the show where we read your comments on our YouTube channel and we respond to them and we answer your questions. So let's get right into it. The first comment that I see here is from a Teresa, and she says, "Love this. I'm going through this now from a fall in a major department store." And she's responding to our video of a $625,000 trip and fall settlement, how we did it. And that was part of a Trial Stories podcast that we did. I'm glad that, and I'm grateful for the fact that, people who are going through something similar, like a fall in a major department store, can see a video of how we successfully handled the case and that it's helpful for them and they could use it, maybe speak to their lawyer about it or use the information to get the right treatment, whatever they need. And if they need more of a confidential, free consultation, they could just text me, and that's 347-566-9595. And then I've been doing some calls as well. Skunk says, "You are such a kind and comforting person in a time that can be so difficult for us. Thank you for being you." Oh, thank you. I really appreciate that. Seeing things like that, hearing things like that helps you to then get motivation to keep making videos and to do even better, because you're helping people, which is my goal. My goal is helping serious injury victims and their families. And if it is helpful, then that kind of gives you the rocket fuel to do more. So thank you for that. And here's a question from Korea. And the question is, "I tripped and fell on a public sidewalk near a bus stop. I fractured my knee. I was in the hospital overnight. I had physical therapy, water therapy, and now we're in discovery. How long does this take and how much is it worth? The sidewalk was uplifted from a tree root." The person that comes out to measure the sidewalk says we have money shots, 1.5 inches, meaning pictures. Oh, I see. I think I see what you mean. Like the fact that it's 1.5 inches raised is significant enough to be actionable under the law. So yeah, that makes it better. I'd have to know a little bit more, like where did it happen, what state you're in, because each state, or sometimes even each city, has different rules. For example, if it happened in, let's say, Brooklyn, you would sue the landlord. So if it's like a public sidewalk and it happened in front of a building, you sue the landlord of that building, and it's known as the adjacent property owner because it's in front of their land and they are responsible for the sidewalk in front of their building. But if it happened in a bus stop where there's no building behind the bus stop and it's just, a bus stop or a curb, that would then be the city of New York. You'd have to sue the city. So it'd be completely different. Like suing the city would be one thing, suing a landlord would be another type of case. Because when you sue the landlord, you're going against a private defendant and they have insurance and you could sometimes settle quickly. But when you're suing the city, they're self-insured. And while there's no cap, like with a landlord, they might only have $1 million in insurance. But with the city, there's no cap. So you could potentially get more money, but the city's very slow, and you go to a city part in the courthouse and the case could just kind of drag on. And if you try to settle early, they're going to give you like pennies on the dollar. So it's like two separate types of cases. That's why I can't really tell you how long or how much. But if you fractured your knee, depending on if you need any kind of surgery, if it's a simple fracture that's going to heal without surgery, how much also depends on where. Like again, like in Brooklyn, just a fractured knee, no surgery could be worth, depending also on where you had the fracture, could be worth anywhere from like 100, 200,000, maybe more than that. So, those cases, that kind of question is probably better for a consult where you text me and we could set up a call, because it's very intricate. I couldn't really give you generalities because it may not apply. Like if your case happened somewhere else, right, like in Florida or in California, it could be completely different, and I'm not familiar with the laws on that there. Here's a question from Daniel, and he says, "I love this channel. These are absolutely the attorneys I want fighting on my behalf. They're competent, knowledgeable, and experienced. Congrats on your win." And he's responding to our video, "Shocking Settlement, How Advanced Brain Scans Revealed $3 million." And that was the $3 million, 3.1 actually, that we did recently, just a few months ago, earlier this summer. So that's great. Yeah, that's great. Thank you for that. And I'm happy that it was helpful. And then Ricey says, nice info. I have finally hit a mediation opportunity meeting they had asked me about to go for a full day. I had to reschedule this for a later date due to some other things. I have a feeling they are going to want to try to work something out and get this over with. I will not, however, be a simp for pennies. They know this after depositions. My chronic pain is lifelong in treatments. Okay, that's good. So yeah, good luck, good luck. I mean, I always say, you know, if you're gonna go for a mediation, have your lawyer work out some parameters with the other side first. Like for example, if they're gonna take you to a mediation, you have to know how much insurance they have, the primary insurance. Also know the umbrella or the excess policy, because sometimes you could have 1 million in primary with another like 3 or 5 million or even more in excess. So find all that out before you agree to the mediation. Also, have them give you a good faith offer. So meaning once you find out how much insurance they have, let's say they have 1 million with a 5 million excess, well, you know they have 6, and then based on all your injuries, discuss with your lawyer what you want to get. For example, you would say, I want to demand or I want to try to get like 5, but I would never take less than 3. So then you have to tell them in a settlement letter, hey, I want like, let's say 5, and then have them give you a good faith offer. So before the mediation, have them give you like something like at least, you know, 500,000, because that's a good faith offer, right? They're giving you $500,000 and they're coming to the table at a mediation. Then you know the mediation is going to prove fruitful potentially, because, you know, you're at, you know, your bottom line is 3.5, you already have 500 on the table, and it's just a question of getting to that middle number between 500,000 and 3.5 million. So maybe you can get to like 1.8, maybe you get to 2, and you settle the case. But if they're not giving you any number at all, so then, you know, I don't like going to those mediations, because like, you know, you can't just expect like magic to just happen at a mediation. A mediation is not a magic show, right? The judge is not a magician. The defendants are not magicians. It's not a magic show. If they're not giving you any money before, you're not just going to show up and magically they're going to throw millions at you. What they're going to do is they're going to use the mediation to tell you how bad your case is, to make up stuff about, you know, how they're going to delay the case, how they're going to, you know, drag you through more litigation, why if you don't take like some lowball number like 20,000, they're going to, you know, win basically. So then what they're trying to do is like kind of dishearten you and take away your belief that you could really get a big, you know, life-changing number, basically take away your belief that you can get full justice. And this is a scheme that they know and they plan, right? So just, I don't want you to fall into that trap. So that's why I always like to get a good faith offer, because then you know, hey, I'm going to this mediation to really get a real settlement number, as opposed to I'm going to this mediation to then, because, you know, if your lawyer takes you in there without a good faith offer and they start lowballing and saying this is worth 20K, there's no liability, whatever argument they make, there's so many arguments you could make. But the point is, if they do that, then you're going to look at your lawyer and you're going to be like, why did you bring me here? What did you bring me here? Just to get yelled at? You know, what's the point of this? And then I'm paying like $600 an hour to this judge, and the whole mediation bill could be like $2,000. It just doesn't make sense. And you waste your time sitting there, and your lawyer wasted time writing like a 20-page mediation brief, and for what, you know? And so again, like they know this, these billion-dollar insurance companies, and this is like their part of their modus operandi. This is part of their plan of how they litigate. So just don't fall into that trap. Okay, and then Frankie says, what does it mean when you see an update by Unicourts that my lawyer filed a demand of insurance? Thank you, sir. I wish I had known before. So yeah, so if they filed the demand for insurance, they're probably just trying to find out, like what I just talked about, like how much insurance there is. There's the primary policy, and then sometimes there'll also be like excess or umbrella, depending on the type of case. Again, like in a commercial case, if you're suing a building or like a mall, something like that, they usually have excess umbrella. If it's a truck, they might have, you know, $1 million primary and then another 3 million umbrella. I had one case with a big building in Manhattan where we had $1 million primary and there was like 25 million excess, right? But some smaller buildings might just have like a homeowner's, like, you know, 350, 500, and there's no excess. Or cars, you could have a 25 policy. Those don't really have excess because it's a minimal $25,000 policy. But sometimes you have a 250 policy, and the 250 policy could have $1 million in excess or even 3 million in excess. So usually excess on automobiles starts with 250. So they're trying to just find that out. Now, I don't know what state you're in. I guess you have to file that with the courts to try to get that. A lot of the times that's just automatic. Like in New York, there's multiple different CPLR provisions. I think one of them is 3101, maybe F, and there's another one. I forget the section, but basically they're all saying the same thing, that this is just something you're entitled to know how much insurance there is, and you're entitled to both the primary and the excess. So you want to always get that. Okay, and then Carla asks, I'm in Oklahoma. I had a tow truck driver that was on the shoulder of the Muskogee Turnpike. I stayed in the right lane, but I reduced my speed. The tow truck pulled out in front of me. I hit the brakes. Then I heard the truck driver get on the gas as if he was taking off. I released the brake. Then I realized that he had stopped in my lane. It was hard to see because of the bright lights on the back of the truck. I ended up running into the back of the truck. The driver apologized for pulling out in front of me, but I was deemed at fault even though the driver pulled out in front of me. I had an MRI and it showed a brain microhemorrhage and brain bleed. I see another lawyer this week even though I got the ticket. How do you see my chances in court or settlement out of court? Yeah, I mean, you should be fine because, just based on what you said, just, speak to the lawyer, make sure they're a real trial lawyer, that they know how to handle brain injuries, because that's a very subspecialty. So you need somebody who knows how to present those cases, who's won, millions and millions of dollars, who's won the exact amount that you want to get in your case in the past. That's critical because brain injuries, not a lot of lawyers know how to do them. And then in terms of the liability, you just have to explain what you just said, maybe hire an expert like an accident reconstructionist, but the lawyer can also do their own investigation and try to prove that. But yeah, like if a truck is in the shoulder and you're in the right lane, you're entitled to drive in the right lane. If they pull out in front of you to not give you enough time to stop, or if they pull out right in front of you, it's all time and distance. Like if you're driving here and they pull out right in front of you and you're going at speed, there's nothing you can do. But if they pull out 2 car lengths in front of you, well, then you have to slow down. So it's just whatever was reasonable, whatever is, whatever happened. So it's just based on that. You can, of course, get discovery, like depositions of the truck driver, your deposition, possibly there's like dash cam video, there's black boxes, there's a lot of other things that could support your case. But I don't think that you have to worry about if the police somehow deemed you at fault, because the police come to the scene after everything's already said and done, and they could have done it based on what the truck driver told them, or they could have, been buddy-buddy with the truck driver, whatever. It doesn't really kill your case. It's more about what actually happened. So I think you have a shot to win that, especially with a serious injury. And even if, they give a higher percentage of fault to you and a lower percentage to the defendant, if the defendant has a large policy and you have this brain hemorrhage, you could still get, it'll be discounted because of the liability percentage that is your own, but it could still be a significant amount. So yeah, I think the case still has potential. One Shot says L4, L5, C4, C7 in my spine doctor's report. In my case, I'm in Florida. The case is in New York Supreme. Can I be forced to go to New York for a DME? Yeah, so usually the DME is based on where the lawsuit is pending, right? So if the case is in New York and you started the case in New York and then you just happen to move to, you can move anywhere, right? You can move to China, Florida, California, whatever. It doesn't matter. They're not going to bring the doctor to you to where you moved. It's where you brought the case and where the case is pending. So yeah, you do have to come to New York for the IME, DME, but it's just like one visit, probably one day. And then Tiny the Bulldog responding to how defense lawyers and insurance companies delay cases. And he says this should be against the law. And I agree, yeah, it should be, because sometimes they delay cases and it's just not right, because people deserve their day in court. And, of course, if something is reasonable, you need some time, you can get a little bit of a delay, but sometimes they delay these cases for like years and years and for no reason. So yeah, and each, judge has their own like part rules, and sometimes they try to create these rules to make it more efficient, but oftentimes doing that somehow backfires, and their own rules prevent efficiency, right? Prevent depositions, prevent discovery, and just allow these long adjournments, which really hurts the plaintiff. And then Mr. Funk talks about breaking Tesla verdict, my video about the breaking Tesla $242 million verdict, and he says it wasn't really a good verdict for opposing counsel or their client. I think, like, you know, they could probably handle it. It's like Elon Musk and Tesla, they have billions, so. And, you know, and then also you have to look at it this way, like if Tesla is going to say they have the best self-driving car on the market, then those can't just be empty words, right? They can't be lies. Tesla is a powerful, like super wealthy corporation, right? In this space, the self-driving space. So they should not be allowed to lie and cover up the truth. And that's what they did in that case. If you look at my video, because they're saying like, we don't have any black box. We don't have any proof that the autopilot wasn't working. And they did. And the plaintiff had to get like a computer hacker to like hack in, and you shouldn't have to do that, right? What if the plaintiff couldn't get a computer hacker to like hack in and look at the black box data, the electronic control module? Then Tesla would have won and the plaintiff would have gotten nothing, and they would have been able to like have this autopilot system that doesn't work, that doesn't see pedestrians, that killed somebody, and just get away with it, right? So I wouldn't worry too much about opposing counsel or that the verdict wasn't good for their client. I mean, I would worry more about what they're doing, this corporate deception. It's almost like it was punitive in that case for $242 million, but how can you do that, you know? You should not be allowed to lie and cover up the truth. Otherwise, it's like they get absolute power, and you know what happens when somebody gets absolute power. It corrupts absolutely, and it does so at the expense of innocent lives, which is, you know, what happened here. So 242 million doesn't bring anybody back. They still, a person died because of this, and another person was like seriously injured for the rest of their life with a brain injury. So it's still tragic, you know, from their perspective and from everybody's perspective. Here's a question from ARG. He says, I was supposed to receive an offer last week, but my lawyer said he will let me know once they receive one. I have multiple herniated discs and suffer anxiety episodes from a rear end by an 18-wheeler. What could be going on? If the doctor said I needed epidural injections 2 months ago, and if pain has not gone away, can I decide to take them now if no offer has come through? Yeah, I mean, of course, you can do additional treatment at any time. I mean, even if you get an offer, it doesn't mean you have to take it, right? The first offer might be low. If you haven't even had epidurals, then, you know, basically it's a soft tissue case. If there's no surgery, you have, let's say, a bulging disc, herniated disc, you're going to a chiropractor, your recommended epidurals, which are just pain relief shots, right? But you haven't even done the pain relief shots. So the first offer might be low, it might be like 20K, 30K. So you could still continue to get treatment if the doctor says you need it and you feel like the doctor is right, you can get a second opinion. And then if you agree, just go ahead and do it. Then you have the epidurals, then there's other things you can do. It usually goes step by step. If the epidurals don't help, there's a percutaneous discectomy, which is a minimally invasive surgery that actually removes the leak from the disc. And we just had a trial actually yesterday. Richard did it. You know, Richard, he was, we did a few videos together, like the 3.1 million case and the other case for 2.2 million. He actually did it himself, I think in, what county? I think he was in Brooklyn. Yeah, in Brooklyn yesterday. And at 5 p.m. he got a verdict and it was 300,000. And actually, I got to tell him and other people in my office that, like, I told you so, because, like, you know, my office manager and me, we told him, hey, go to court. He wanted to at one point settle it because they were offering him some money, but it was only 100,000 policy, and they were trying to give him like 60. And he was like, maybe we should take it. I said, no, go to trial, you know. And he ended up getting 300. So you see, you could do really well even on these this was a one-day summary jury quick trial. But maybe I'll do a video about that case too. I'll bring him back or have him, you know, fill me in and I could do it. But yeah, so yeah, absolutely. The answer is yes, you could do the treatment. And, you know, I definitely, you know, advise that, because then the offer will be much higher. Here's a question from Frankie. Hi, Arkady. So I have 2 depositions so far from 10 a.m. to 4:30, and this one was for liability and damages, but I don't know, but I'm getting treatment from a neurologist and psychotherapy with cognitive therapy, and it was not there on file. They said we don't have this, so another deposition will be made because of this. And actually my deposition was fine, but the defendant lawyer was rude and made me mad, trying to catch me making a question 2 or 3 times. And during my deposition phase, I seen my lawyer sent a demand of insurance. I seen it in Unicourts. What do you think about this? Thanks. Yeah, so definitely don't get mad, stay calm and professional, just answer their questions. If the lawyer keeps asking the same question over and over, that's an objection that your lawyer has to make, known as asked and answered. They can't do that, right? Because once you ask a question, that question's been answered. You can't just go and ask the question again, otherwise you'd be there forever, right? And then a lot of states have limits, like 7 hours for a deposition. And I think I understand what you're saying, that it was from 10 a.m. to 4:30, but because they didn't have some medical records from a neurologist or a psychotherapist, they're saying because they didn't have those records, they want to call you back to just do a deposition about those records, which is going to be really quick. So that shouldn't really add too much to it. And the fact that your lawyer is asking for the insurance information, I mean, they really should have known that before the deposition, but if they're better late than never kind of thing, yeah, definitely get that. But it sounds like, it could be a nice case. It's hard for me to say, but unless I do like a deep dive with you and we do a consultation, which I'm happy to do if you'd like to text me. But, but just based on what you said here, it seems like pretty standard. But yeah, so I think that once you know how much insurance they have, you can send a settlement letter and hopefully resolve the case. Korea Armstrong says, how much of an award do you think upper arm and shoulder tendon partial tear? I got injured on a metro bus in LA. The back door slammed on my upper arm and I had an MRI, and now I'm going to do a PRP injection and physical therapy. Right, so if you have a partial tear of the shoulder tendon but with no surgery, just a PRP, which is the platelet-rich plasma injections, that could still be worth, maybe 100,000, maybe more, like, 150, 200. It depends on all the everything, right? It's not just that. It's also the medical bills that you have, and also the future medical costs, whether you have lost wages, how it impacted your overall life, and as well as the liability of what that metro bus did wrong, how you got injured, the door, if it was defective, if you could have evidence that it was defective, it shouldn't have slammed on you like that. So yeah, it could be a significant case for sure. And here's a question from Doretta. She says, how much should the policy be if someone hit you in a U-Haul truck? So the defendant will tell you the full insurance. You just have to ask them, right? Just U-Haul might have a lot of different trucks. Some might have $1 million, some might have less. So you just have to ask them how much that particular vehicle has. Okay, so please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. If you want a video about a specific topic, just let us know. If we did a consult with you and you were happy with our consultation and we gave you some good advice, please leave us a review. The links are in the description. That's really helpful. But otherwise, we're going to continue to do a few of these raw laws where we answer your comments and questions live. This particular episode, Comment Counsel, where we discuss the comments on our YouTube and answer your questions there. And then, of course, we also are going to have more topic videos, including verdict searches, trials, the legal process, all about civil justice and everything related to that. Okay, everyone, have a great day. Bye-bye.